Having seen Supreme Court's decision in Nitya Anand's case, now we move to maintenance, which is a bone of contention in a large number of cases relating to matrimonial dispute. I would request you that the thinking of the Supreme Court in the matter of Rajesh versus Neha may kindly be elucidated for the benefit of the listeners.
First of all, just to explain briefly, what is the statutory position of law on the point of maintenance? Now, maintenance is an uncharted ship in the troubled seas of marital discord, with no sail, no rudder, and no course. It is just there is a one word usage in the Hindu Marriage Act on interim maintenance in section 24, permanent maintenance or alimony in section 25 with property settlement pitched in, and last of all, custody of children under 26. Now, these are all ancillary reliefs, meaning they are subordinate reliefs or reliefs sought in a petition for divorce as smaller details to proceed with. Now, what is the principle for division? How do you determine quantum? What is the procedure for disclosure of assets? Is not written in any law. So, if you don't get enough, you go to section 125 of the CRPC. You want a better bit, you go to the Prevention of Women Against Domestic Violence Act 2005, and you see maintenance. You are still not satisfied, you use the back door and use 406, 498, matrimonial cruelty dowry. So you go around as you're advised to start all, and you can use start all simultaneously. You can pursue all simultaneously. Total freedom. Quantum may be determined on the basis of what you've been granted or not granted. But then it's a freedom. It's an unbridled horse, no saddle. So, what are the courts doing? The courts are deciding on the basis of affidavits. And if people don't file affidavits, there is nothing the court can do. I may be driving an Audi. I may be living in a fancy detached bungalow. I may be having yachts. But I say I don't pay tax. I have no income. So what do I give to the woman? Likewise, there is a sit-home spouse who's given up a career or a job to bring up a family. The husband says she has no income. I'm not going to give her money all her life. So these are areas which found no moor, which found no anchor to stand, to sit, or to sail with. So it was an inequitable decision of assets. And it was just a little small thing on the side, which the judge, while granting divorce, and said, "ठीक है, let's sort this out also. Give us something, sort it out." That's not the way to deal with it. See, abroad, you get a decree nisi for the asking, meaning you get divorced for the asking. But till you settle matrimonial property and custody of children, it's not made absolute. In India, divorce is made absolute and all other things are kept hanging. And if you have to execute the decree, that itself is another battle. First, you find whether he has assets. You have to seek attachment, you have to seek this and that and whatnot. You have won the war, you have won the battle, but there is another war. You are still on the ground fighting. So this created a very anomalous situation. Attempts were made by Justice Midda and the Delhi High Court to draft different kinds of affidavits, provisions, mandatory things, and the rules. Under the Act, you can make Hindu Marriage Act, Special Marriage Act, every High Court can make rules. Under the CPC, also rules can be made by every High Court. So everybody was blowing his own trumpet. So we were in an area where we don't know what to do. Then in Neha versus Renish, Justice Hindu Malhotra, in a brilliant erudite verdict, despite being from a industrial disputes labor court chambers of her esteemed father, and despite her being a very open-minded judge and being a specialist in arbitration law, she authored a brilliant judgment on maintenance and the principles of maintenance. And there are guidelines under 142. Same 142. The Artha Shastra was used again to lay down law in shape of guidelines. This is how law in the family side is evolving. Example, standing example, Vishakha. Sexual harassment in workplaces starts with guidelines, ends up as a law. Adoptions, Lakshmikant Pandey, 84, 86, 88, ends up with adoption under the JJ Act. So we move slowly. Parliament takes about 30 years to grind, find the right machine, find the right people to make a base, and then maybe after 25 years. But in maintenance, we are still far away. Rome is still far away. Delhi do that. But then the judgment has laid down guidelines. So you have a format. You have to disclose in the format what you earn, what you spend, what do you pay tax on, what is your contribution to the matrimonial home. Likewise, the other spouse has to explain what she did to the marriage. She contributed in money, love, care, and affection. And what else did she do? And so forth. There is now a formula. We have, in one word parlance, we have a need based family maintenance. That's not enough. Abroad, in most jurisdictions, everything is half enough. Before, after, later, sooner, whatever. You take the dog, I'll take the cat. You take the yacht, I'll take the boat. You take the villa, I will take the mansion. So that's how people divide. So we have to have some semblance, some sense, some method of evolving justice. A sit-home spouse must be compensated. So therefore, Neha versus Rajneesh by Justice Sanju Malhotra is a watershed. And it has given a lot of clarity to the family court judges who have absolutely no clue on what to do. Now there is a mandate, you have to file an affidavit, you can't conceal. It is on oath. If you lie, you are guilty of perjury. So the court has now got ammunition on the basis of which they can decide logically, relevantly, and legitimately what is to be given as maintenance and what is not to be given as maintenance. But sir, this still comes with a note of caution. There is still a proviso. In 142, we balance the scales in crores now. Justice Vikram Nath has given 6 crores, 10 crores. You are at a stage where you have burned your years together, you have done everything, and then you settle. So therefore, we still have a lot to go. We still have miles to go.
Thanks. Significance of Rajesh versus Neha. Justice Hindu Malhotra has been brilliantly brought out by you. And after that, we move to Rupak Rathi's case. Now, that was a matter involving divorce of an Indian couple in UK. Now, what is the importance, utility of this case? Would you like to explain?
Sir, the question which arose in this case was relating to recognition of foreign marriage in response to a divorce petition filed in India. I was appointed as an amicus in this case by Justice Rajiv Narayan Raya, who said that there is a 1991 judgment of the Supreme Court in Y. Venkatalaxmi Rao, which has laid down principles in accordance with Section 13 CPC as to when will we recognize a foreign and how will we treat a foreign judgment on divorce on grounds of the foreign jurisdiction which are not part of the law in the Indian jurisdiction. So Narasimha Rao had to be interpreted. And the Honorable Court was of the view that it doesn't give a lot of clarity. So we did a lot of research. We started reading on the concept. We obviously could differ with the Supreme Court. It had the content, but it needed more enunciation. The situation before the family court in Panchkula was that the parties had married according to Hindu law in Haryana. They had gone abroad. They had willingly got a divorce. Both of them had agreed and they got a divorce on irretrievable breakdown in the UK. Things became ugly. The woman came back and she filed multiple things in the family court in particular, including a divorce petition, saying that the foreign divorce is not according to Indian law. So the husband came up in response to the notice and summons in a maintainability application under Order 7211 saying this petition is not maintainable. This has been heard and decided in England. She participated. Now, the question before the court was can a maintainability application under Order 7211 CPC determine the divorce issue on merits? Can the application per se lead to the dismissal of the divorce petition without adjudicating the matter on merits? Or should the court go on? Now, the family court decided to dismiss the application, saying this question of maintainability is not a question which is separable from the merits. Under Order 14, Rule 2, Sub Rule 2 CBC, only if there is a pure question of law can the court determine a maintainability. If you take a matrimonial matter to the labor court, if you take a criminal case to the rent court, these are issues of maintainability. Section 9 CPC, courts have jurisdiction to try all suits unless barred, which is a principle which travels everywhere. Now, this is not a question of maintainability per se on law. So, therefore, the issue of maintainability cannot be segregated from the issues. We'll frame issues and we will decide maintainability is a preliminary issue. So, in this judgment, we watered down the interpretation of Narasimha Rao, 1991 Supreme Court, and explained how the process is to go on. And it proved to be a watershed for family courts because then the family courts know what they are dealing with. Now, you can imagine the predicament of a family court judge who sometimes has no clue on what it is all about because he hasn't grown up with these things. So, this judgment in Rupak Rathi versus Anita Chaudhary gave a lot of clarity on how a foreign court judgment is to be read, how Narasimha Rao's judgment of 1991 is to be read, and how is the family court supposed to take it up. My report is extensively quoted, but the judge gave his own conclusions. And he said, no, this is what I think the family court should do. So again, where the statute has a drop, our courts come out. Brilliant judgments in appellate, revisional, or writ jurisdiction by superior courts. They do the patchwork. You see, I think a constitutional court is like a tailor. He gets a new suit, he cuts it to size, he takes the measurements, and then tailors the relief. But it's about time the parliament starts making new cloth, meaning new statutes.
Thank you.